Welcome to the Business Law, Estate Planning, and Estates Podcast.
Hello, and welcome back to the Business Law, Estate Planning, and Estate Podcast with attorney Thomas LaPorte. Tom is the founder of LaPorte Law Group, PLLC, with offices in Portsmouth, New Hampshire, and Andover, Massachusetts, that is. With more than 30 years of experience, he helps individuals, families, and business owners protect their assets, plan for the future, and navigate estates and business matters with clarity. I'm Lisa Mosbey, your host, and today we're talking about why estate planning matters, what can happen without a plan in place, and how the core documents work together to protect you and your family. Welcome, Tom. Thank you so much for joining me again.
Hi, Lisa. How you doing?
I'm well. Tom, why should we bother with an estate plan at all?
Well, the alternative is worse.
I know. It is. It is.
An estate plan, first and foremost, I guess the first thing that jumps to mind is that the alternative is that when we pass away, an estate plan doesn't just deal with post-death issues. It involves documents that are very important for us during our lifetimes. But if we don't have a will in place, then we need to, or someone in your family is going to have to petition a probate court. And they're some of the most busiest courts in the country. And to be appointed the administrator of your estate. And I know in New Hampshire, in particular, the court is going to require consents called assents from all the interested parties, who are all of your descendants, and oftentimes parents, and sometimes even siblings, definitely siblings and cousins, depending on who is around, to consent to your petitioning the court to be appointed the administrator of your estate. That's hurdle number one. Hurdle number two is, and could be for any of the states that I practice in, the courts may require you to post or obtain a surety bond, which costs money, and it's like insurance to insure the court and everybody else that may be interested in the assets in the estate. It protects against the appointed person from stealing estate assets. And the intestacy statutes go into effect as well. So intestate means without a will. Testate means with a will. And in some states like New Hampshire, the statute is so antiquated that if the spouse is female, the wife or putative spouse is female, then in certain circumstances, once if assets are over a certain level, then the spouse, the female spouse, who's the widow, if they have children, the deceased person and the widow, then the mother, the spouse, the widow, does not get everything. And it goes back to the days when it was assumed that women couldn't manage property as well as men. It's still on the books in one of the states I practice in, and I presume it's in some other states as well. It's sort of ridiculous, but that's the alternative to not having a will. Without the other documents, where durable power of attorney, your healthcare proxy, or durable power of attorney for healthcare, they're interchangeable name-wise, and a HIPAA authorization. If you're incapacitated, you are going to run into many, many delays where things need to get done, like paying a mortgage bill. And the alternative is going back to a probate court and seeking either a guardianship or conservatorship, which is very, very difficult. And the courts are very reluctant to grant them as well. And then they're going to want to limit the powers of the guardian and the conservator because they were trying to respect the person's liberty and independence. The HIPAA form is necessary. It's a one-page document. It's not a big deal, so it's easy to get. It should be gotten, because if someone is hurt or injured or ill, a loved one will not be able to get any health information about that person without being named as an authorized person under a HIPAA authorization form.
And let's talk a little bit about the tax reasons to complete an estate plan.
Well, in the states that have their own estate taxes, Massachusetts being one of the most notorious, and Maine also having an estate tax. Massachusetts has a very low um, exemption amount, meaning if one person goes over when they pass away, if their assets are worth more than $2 million, and it used to be worse, they have modified it a bit, but if they go over $2 million, it's very easy to do so with the value of homes these days and equity in homes, as well as the face value of life insurance. That's included too in your taxable estate. Well, with a trust in those states that have state estate taxes, and there is a federal estate tax, but the exemption amounts are so high that many people, unless they have upwards of $15 million each, 30 million between two people, they're not going to encounter the federal estate tax. But laws change. Republicans, Democrats disagree about this all the time. So you really should stay abreast of what the exemption amounts are. But with a trust, you can do some estate tax planning, take advantage of personal exemptions. Um, if you have a will, you're only taking if you're married, for instance, you're only taking advantage of one exemption. With the trust, you are creating an additional person that benefit two people, and you can use two exemptions and avoid those low exempt states estate tax regimens. And you can only do that with a trust.
And Tom, are there non-tax reasons to complete an estate plan?
Absolutely, and most people are more concerned about those, and should be. First of all, if a couple has or a single person has minor children, in the will, which is part of the estate plan, you name your guardians. Um, I alluded to earlier to having to petition the probate court to be uh, appointed administrator. Well, in your will, you nominate your executor, and you say that that executor should be able to serve without getting a surety bond. Those are three reasons right there. Your executor is going to be accepted. You don't need a sense, and the person's not going to need to get a surety bond. Um, and your guardians are in place. Single people that have been in toxic relationships, if they have minor children, well, if that divorced spouse that was part of the former toxic relationship, if you pass away, well, he or she is going to be the guardian, and he's also or she's also going to get control of the assets. What if that person has a drinking problem or is addicted or has a gambling problem? We all see these gambling ads all over the television these days. Well, you may want to appoint a separate person as a trustee of the money for your minor children. And it doesn't have to be just for minor children who will work with your named guardian in your will. These are all reasons to have an estate plan. Um, some of the reasons.
Sure. And I know, Tom, we talked more in depth about powers of attorney in a previous episode, but I'd like for you to define what a durable power of attorney is and why is that so important?
Well, you need to have a durable power of attorney to get the power under the law to I'll give you an example. Lisa, if you're my attorney, in fact, under a durable power of attorney, and there are two types, but um, unless the power of attorney says durable in it and has the language necessary required by law, then Lisa, as my attorney, in fact, you're not going to be able to do all the things that are going to be necessary while I'm incapacitated. I may be unable to tend to my business for a couple of months. It could mean paying my taxes. It could mean paying the mortgage and other important bills, credit cards. And if those aren't taken care of because of a lack of durability with the power of attorney form, then there's late fees, there's interest involved. It could be defaults, and worst case scenarios, foreclosures. All because I don't have one document in place that's appropriately crafted.
And I think that might hold true for other documents as well. Example, healthcare proxy or the HIPAA authorization. You touched on both of those, but what do they actually allow your representative to do on your behalf?
Well, the healthcare proxy, that's the name of it in one of the states I practice in, which is Massachusetts. It's also known as an advance directive, which is a better name for it, frankly. Also called the durable power of attorney for healthcare in New Hampshire. Maine is similar to Massachusetts. And the two parts of let's call it advance directive. Well, the name suggests what it does. Lisa, you appoint me as your healthcare agent under your advance directive, healthcare proxy, durable power of attorney for healthcare, whatever we want to call it. And you, in this document, state what sort of medical care and what your preferences are, and you direct me as your agent to carry out your wishes. So it streamlines and makes very clear um, what the medical providers are going to do when I need health care and I'm unable to speak myself.
And then HIPAA also allows them to get that information, correct?
Yeah, it seems like it seems like the getting the information would be uh, subsumed in your advance directive. Well, it's not. The federal government 30 years ago have decided that a separate document is necessary called a HIPAA authorization, um, where in this case I would appoint you, Lisa, my healthcare agent, certainly, and maybe two or three other people that I trust to get information about how I'm doing, what my healthcare status is, so that they can make informed decisions or at least speak with you, Lisa, my healthcare agent, so that you can make informed decisions to better carry out my wishes in advance. And in New Hampshire, they include a living will component to their version of the advance directive, which deal with end of life or end of quality of life decisions, not just routine um incapacity scenarios.
And Tom, we often hear about the word trust. Everybody should have a trust or nobody should have a trust. There's trust conversations all the time on TV now. How does an irrevocable living trust fit into this plan? And when does that make sense?
I have a colleague that I worked with back in 2017, 18, 19. He's a very, very, very good trust attorney, works for an accounting firm. Um, kind of a nerd, but he's right. And you think about it. And I say that respectfully, actually. Um, and he'll see a new baby and say, "Oh, beautiful baby." And he asks, "Do you have a trust? You should have a trust." Uh, and he makes a good point because with the trust, and you mentioned irrevocable, I'll make the distinction in a minute between revocable and irrevocable. But with the trust, you get to choose, you take the probate court out of the decision making process or the process at all about disposition of your assets. It is with a revocable trust, you do not lose any control. You transfer your assets into the trust during a lifetime, and really should have a will, by the way, with that called the pourable will. So any assets that we don't or not transferred the home, and you use a deed, of course, into the trust during a lifetime, will transfer at the date of your death into the trust. And a revocable trust is flexible. You don't lose control during your lifetime. It allows you to take advantage of exemptions to reduce your estate tax if you're exposed to any estate tax, and they're a state and they're a federal. The states are probably you're more likely to be exposed to a state estate tax if you live in, say, Massachusetts or other states that have low exemption amounts, exempt from estate taxes. Um, It also allows you to manage those assets for your loved ones from the grave. And you don't have to go through the cumbersome and more expensive probate process. In Massachusetts, takes at least a year because there's a 12-month period for creditors to make claims against the estate. New Hampshire's uh, less so, 6 months. Maine, I believe that's 12 months as well. I'm doing more and more work in Maine lately. Um, but with a trust, it's a private contract and the law respects that. So it minimizes your probate. It cuts down on costs, pay some money up front for the trust, but On average, I think that the cost of probate is about 3 times that amount as much these days, because of the amount of forms and the accountings, the inventories that have to be done, and the time that it takes, um, as well as the, consents that one often has to get from family members all over the country or around the world. I had to go to Hong Kong. I've had to go to South Africa. I've gone to Kenya to get consents in a sense for, various probates. Um, and I'll finish with management of the money. You can love your loved ones from the grave, if you will. So, for instance, if you have children, you can have the trustee provide them everything they need for their education, post-secondary school, books, tuition, room and board you would like, money towards a first wedding with maybe a dollar cap, money towards investing in their own business, but perhaps not another person's business because that person may be a con artist. Um, and what's the fourth one? I call them the four horsemen or four horse persons. Um, it'll come to me in a minute, but it also gives the trustee discretion to dole out monies for the person that's going to go to an Ivy League versus the person that's going to go to, and there's a very good motorcycle school in Arizona, but it's cheaper than Yale. So it doesn't have to be perfectly equal. And the trust can make offsetting distributions to make it more equal. Um, Also, you can put in the trust, look, I want the trustee, and it's yourself during lifetime. Or if we're married, it's my spouse and myself, for instance. But if I'm gone, the backup trustee, maybe my brother, will provide monies at 25% as the youngest each reaches the age of 23. Why is that? Because we're going to college or we're going to post-secondary school, like that motorcycle school, and they may be applying for financial aid. Well, if they're 18 and they don't have a trust and there's just a will or there's no will at all, then if they're a beneficiary, they own that money at age 18. And it's going to disqualify them from financial aid. Also, you could protect the person that may be addictive, have an addiction, maybe in a toxic relationship and married, and we don't want that money to be part of a divorce or property division. So all of these things and more can be creatively addressed inside of a trust. Um, it's a much better way to take care of your money than even a will, and certainly a will is better than having none at all. So irrevocable. You asked about it, right, Lisa?
I did, yeah.
Okay. Irrevocable trusts are used to protect assets. Many people would like to try and preserve a home, for instance, if they anticipate having to go to having to go into a nursing home. So it's getting more and more difficult because there's less public dollars, less Medicaid dollars to go around. So the states are very, very discerning on whether or not the trust will protect the assets that's been transferred into it, primarily a home. It's complicated, but you have to start with an irrevocable trust where the person that is creating the trust does actually give up control of the assets. You're irrevocably giving up control of the assets. The ones that I do, I accompany that with a use and occupancy agreement. So if it's me and I'm concerned I'm going into a nursing home at some point in the future, at least I get to use and occupy the residence. Or there's a lease involved where I pay the trustee, and it's got to be close to fair rental value. Um, Use and occupancy is a little bit more flexible. Um, Different states have different enforcement mechanisms and recognizing whether or not I really have access to the principal asset or not. That's the rule. I can't have any possible access to the principal. And then there's a 5-year look back period that has to go by before that irrevocable trust is effective. More wealthy people can use irrevocable trusts to make a gift to charity. They can get a large charitable deduction against their income taxes. They still get the income for life, and they can use that income to buy another irrevocable trust to purchase life insurance. It's not in their taxable estate for estate tax. And the life insurance, when that donor, say it's me, I've got a lot of money, I've made a donation to ASPCA. or feed the children, that life insurance is going to pay off. And my beneficiaries, my kids, who may say, well, Dad, you're making a gift to a charity, and what about us? Well, there's a life insurance that's going to pay you all that money. It's called a wealth replacement trust. So they're two irrevocable trusts that work with each other. Those are a couple of examples of an irrevocable trust.
Thank you for that. And I also want to say thank you for tying all these documents together so that we can see how a real life plan actually works. I know folks probably are asking, how do I get this? How do I set this stuff up? As we end today, I'd like for you to share how people can reach you.
Sure. Well, thank you for the opportunity. And uh, first of all, people are not alone. A lot of people uh, find these topics or these words, the word trust, to be somewhat mysterious. So if they want to run an inquiry by me or a question by me, they can certainly call me or they can email me. Both my email address and the phone number are on my website, laportelawgroup.net, N-E-T. And they can also book a 15-minute appointment. It doesn't cost them anything, and they can run some questions by me, and I can at least give them some direction. If I can help them, I usually know people have been around for 33 years that can help them. So, yeah, my website, laportelawgroup.net, is the best way.
Great. Thank you, Tom. And that's it for today's episode of Business Law, Estate Planning, and Probate Podcast. Thank you so much for listening. And don't forget to subscribe, share, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.